Good morning. My name is Ashley Adams. I am the president of Adams & Associates. We're really glad that you are joining us today. We're here to give you some information about how to obtain an order of protection. First of all, what is an order of protection? An order of protection is an order issued by the court to prevent someone from committing an act of domestic violence. Now, most people think of domestic violence as actual violence, but the definition of domestic violence is actually very broad. It includes things like intimidation, harassment, and endangerment. It also includes things like interfering with a child custodial relationship, trespass on someone's property, or damage to someone's property. Of course, it includes basic things like restraint and kidnapping and trying to keep someone prisoner, as well as assault with one's body or assault with a deadly weapon. Another act of domestic violence, which a lot of people don't know about, is surreptitiously recording someone either by video or audio. That's considered to be an act of violence if it's done without someone's consent. And then finally, stalking is also included as an act of violence. Now, there's a difference between an order of protection and an injunction against harassment. We also have a video on our website about injunctions against harassment, but orders of protection are designed for the familial relationship. And what I mean by that, and it's very simple to remember, if you're related to somebody by blood or you're related to somebody by marriage, that's included as a familial relationship. You also can get an order of protection against somebody you've lived with in the past or someone you live with now. So let's talk about how you actually get an order of protection. What's the first thing that you need to do? Well, the first thing that you need to do is consult with a lawyer. And the reason is that people like me who have been doing this for a long time, we can help you through an already stressful situation and help to make things a little bit easier, because the court system can be intimidating as well as the paperwork. And we're here to help if you are able to get an attorney. If you are unable to afford an attorney, here in Arizona, our courts try to make it really easy for people to get orders of protection. The first thing you want to do is go to one of the Maricopa County Justice Centers. There's a center downtown, there's a center out in Mesa, and there's one in Northeast Phoenix, which is on the 51 in Union Hills. And I find that one to be the most user-friendly center because you can go in, there are computer terminals, and you can fill out all of the forms right online, which is really convenient. So when you get to the court center, let the clerk know that you're there to file an order of protection. When you fill out the paperwork, you're going to need to provide your name, your address, the defendant's name, and the defendant's address. You will also need to describe in your petition all of the acts of violence, like the ones I just talked about. Tell the court what's been going on, why you're afraid, and why you think you need an order of protection. And then finally, you need to ask the court for the relief that you want. Do you want the defendant to stay away from your home, or do you want the defendant to stay away from your work, or both? All right, so once you finish that petition, it will be submitted to the judge. You'll be called into the courtroom, you'll be sworn in, and the judge will listen to what you have to say and decide whether an order of protection is appropriate. If it is, you will need to personally serve that order of protection on the defendant. You cannot mail it. You can either hire a private process server, or you can have the sheriff serve it. The problem with the sheriff is there's usually a backup, and so if it's an emergency situation, you'll want to hire a private process server. Now let's talk about if you're a defendant and you get an order of protection served on you, but you don't think it's valid. You have 10 days to request a hearing. And at that hearing, and the judge will set it as long as you file a motion and ask for it, at that hearing, the judge will listen to all of the evidence. The plaintiff has the burden of proof. The plaintiff can put on witnesses, testimony, show text messages, phone calls, photos. But the defendant has the right to cross-examine the plaintiff, to also call his or her own witnesses, and to testify if he or she decides to do so. And the judge will look at the totality of the circumstances and decide whether an order of protection is appropriate. He'll decide whether it should stay in place, whether it should be modified, or whether it should be quashed. And if that order remains in place, it's good for a period of 1 year. And during that time, it's important that you know the defendant is not allowed to possess any weapons whatsoever. That includes firearms, knives, nunchucks, anything like that. Okay, well, I hope that we were able to help you. And again, if you have any questions, please do not hesitate to call us at 480-219-1366. You can also send us an email through our website at www.azwhitecollarcrime.com. Thank you for joining us today.